India and my dear students. While I came here in this institute, it's for the first time that I am coming to this place, because earlier I had come only at the old venue. I told your director, I said, I am very envious of all these students. For this reason, that when in 1968-66 I stepped into the law college, and perhaps barring me and Mr. Ram Jetmalani, nobody is here who has done his law in 2 years course. At that time we used to be a postgraduate course, but an undergraduate degree of law. Previous law and final law. And in Marathi they used to call, I think you understand Marathi here, quite a few of them. But in Marathi they used to call Vidhi, Upantya Vidhi and Antya Vidhi. As you all know what is meant by Antya Vidhi. Antya Vidhi is funeral in Marathi. Be that as it may. My dear students, we had nothing. No moot courts, no opportunities, no competitions, and very traditionally the law college used to be from 7:30 to 10:30, to be attended in a class of 60 or 70 by 10 or 15 students. Rest of all of them were outstanding students. They all used to stand out and enjoy, perhaps in the canteens or perhaps in the stairs of those are the very popular places, stairs. Be that as it may. But thereafter, the law education changed its pace. Thereafter came 3 years course. It became more professional. Otherwise, to join law was a task if you did not get the admission to MA Economics, if you did not get an admission to MSc Chemistry, if you are thoroughly useless as a student, you went to law, where you did not have to appear in any kind of competition. Whosoever went was admitted. Since it was the last batch of the 2 years course, we were all welcomed by open arms by our principal. Come on, I will have complete students, complete role. And then, with the advent of 3 years course, it started gaining a direction. Only those who wanted to be the lawyers and practice law went and chose this 3 years course. This also went on for quite some time till the 3 years course was replaced by 5 years course. Now you had to decide at your matriculation, 12th class, where you want to go. As if that is not sufficient, in 1985, thanks to the resourcefulness of Mr. Jetmalani, I was also a member of Bar Council, elected from Nagpur area, Vidarbha area, while Ram used to be permanent member of the Bar Council. He used to be invariably elected from Bombay, And there the idea of a national law school started and came Bangalore National Law School. Ram Jethmalani was very heavily criticized by some of our colleagues in the Bar Council that you are trying to create an institution for the elites of the society, for the haves of the society. A common student would not be admitted to these law schools and would not be able to afford them. My dear students, at that time we had never heard of computers. We had never heard of the IT Act, Information Technology. Very few of us had heard about the Intellectual Property Act. Only those who practiced in Bombay. Nobody knew what is IPL, what is patents, what is this, that, registration of patents and trademarks and so on and so forth. Nobody knew. Only very few hundreds, 200, 300 lawyers in Bombay used to practice on that side. But they very jealously guarded their own area. As a tiger guards its own area, they very jealously guarded and did not allow all third-rate students like me in Nagpur University and so on and so forth to enter that area and to create competitions for them. But came 5 years course and the whole law course was revolutionized. Then came the globalization. And that really opened the field for all the lawyers. Otherwise, to go to foreign was a dream only of the engineering students or the medical students. Nobody even thought of going to foreign. Forget about Nehru's and Gandhi who went to England to become the barristers, or some few lawyers, again the sons and daughters of the barristers of Calcutta Kolkata. I'm sorry. Kolkata. Though High Court is still Calcutta High Court. Be that as it may, barring them, nobody thought that after passing the law degree, you can go and you can earn and you can serve. Those were the days, gentlemen. We knew about our law trials from the books on Samuel Lebowitz, and then very, what do you call it, the Perry Mason stories. Perry Mason and Della Street and Paul Drake and whatnot, all those characters. Our first introduction to the criminal trials was through those books. And those books provided fantastic cross-examination by Perry Mason, the lawyer. Therefore, when I stepped into the profession way back in the year 1968 and practiced it for 24 long years before becoming a judge and leaving all my practice and chances to become rich like Ram Jethmalani is, accepted the judgeship. I have seen right from the court of judicial magistrate first class up to the Supreme Court. But those days, to be able to stand and cross-examine in the criminal trial. There is no point in speaking about the criminal trial in front of a giant in that field. He is by far the best trial lawyer in India. And I am not saying this. India says this. But whatever little experience I have, I always found it very easy to conduct a murder trial. But I found it extremely difficult to conduct a trial for the offense like 323, causing hurt. Causing hurt. If I go and tap somebody or slap somebody, what is the cross-examination you are going to do? Rama went and slapped Govinda. Now Rama has come to you. What are you going to ask Govinda? What was the force of that slap? Did you feel like anything? Were you hurt? Or was it just a cajoling by Rama to your cheek because you were found very attractive? What is the cross-examination that you are going to do? Similarly, 307, attempt to murder. Unfortunately, I come from a Chandrapur district, which is a forest district. And once upon a time when there used to be tigers in our country in abundance, I had seen a caricature there in one of the dark bungalows where the tiger is having fork and knife. His one paw is bandaged and he is eating the man. And it was written below, shoot him to die, don't leave him wounded. Same principle applies that if you want to finish off somebody, murder him. But don't leave him wounded because he is there to speak against you. And what are you going to ask him? And how are you going to save him? Therefore, I found the 307 trials to be extremely difficult for conducting. Be that as it may. The criminal trials, particularly in India, is not everybody's cup of tea. You have to develop a wonderful skill, even if you are a complainant. I'm not here to advise, but I want to talk to you. I want to talk to my dear students that yes, international practice, fine, good, international criminal code, very good. But how many of you are going to be in the international criminal code? How many of you are going to practice on the international field? Please, I should not be taken to mean that you should not learn it. You have to learn those skills. Because if you want to survive in today's world, you should be equally adept in the international field. It's not for nothing that this competition was thought out. It is one of the things which would help you. Mooting. In mooting, the student, the first thing that he sheds off is his fear of the court. I still remember when I first stepped into the High Court on 1/9/2016, 1968, I had the difficulty in deciding as to whether I can go in or not. I was a full-fledged lawyer. And then, fortunately, when I got a chance to address the court, When the first question was to me by the judge, I was dumbfounded. Who am I? Who is this man? Who are all these other persons looking at me? What is he asking me? What should I say? Should I say anything or should I not say anything? This is what happens. So the moot court gives you that confidence to rise up and to say something. Say something. Relevant, irrelevant, most of the times it is irrelevant, but then, yes. But you must know how to make irrelevant or how to make irrelevant statement in the garb of a relevant statement. That's precisely what these lawyers do and have been doing. And yes, Mr. Jait Malani has appeared before me at least 25 times, minimum. But this is what he taught when I attended that Bar Council of India meet for the criminal practice. Be firm. Never appear wavering. Be confident. And one thing in the court, there is nothing, that the two words which are never uttered in the court of law, whether it be judicial magistrates court, whether it be Supreme Court's court, Supreme Court. Two words which are never to be uttered in the court are no, my lord. My lord suggests something, says something, and if you say no, my lord, well, my lord decides that very moment that this man is thoroughly useless. The only very good three words in the to be uttered in the court always, that is right, my lord. But when you get the practice in moot courts, the similar such thing, I read the brief. Professor Kulkarni was good enough to give me the brief. I read that Jack and this and that and all those things. I read that. To tell you the truth, if I were there, I would have drawn a zero. I did not know. I don't know. Somebody has drafted that brief very carefully so as not to be understood even by a retired though Supreme Court judge. My compliments to the one who has drafted that brief. But that does not mean that the brief is not to be attended to. Whatever your brief, you have to attend to. You have to develop that classic, very classic expertise in cross-examination. The cross-examination for a civil lawyer, I practice both civil law and criminal law. Who is the best civil lawyer? One who can draft his plaint properly. Who is a best civil side judge? Who, after seeing the plaint and the written statement, comes and frames correct issues? Who is that? Who decides, the lawyer who decides which documents to be presented, which documents not to be presented, which objections taken, which objections not to be taken. Similarly, on the criminal side, who is the best criminal side lawyer? One who decides to take correct defense. Unless you proceed on a correct defense, you can never succeed. The defense can never be slipshod. You have to decide in a murder trial, in any trial for that matter, what is going to be your defense. That is the first stage. My dear students, for succeeding as a trial lawyer, you have to have a vice-like grip on the facts. One fact ignored and it costs you your liberty. You have to have a vice has a perfect grip on the man. If he's a drunkard, well, if he doesn't get to get the alcohol, he can't act. It is that kind of grip. So you have to have a vice-like grip on the facts. Two, you have to have vice-like grip on the language in which you are going to conduct the trial. The language to be understood by the witnesses, the language to be understood by the judge, the language that is going to be understood by your client. Why this language? Because unless you have a grip on the language, you can't frame your questions. Question number 1, I put a very serious question. Disallowed. Next is the reaction by the judge. You must be able to frame the same question but in a different language, in a different. That is the first lesson. And then the third lesson is very, very difficult. You have to have robust common sense. A common sense is a sense which is very uncommonly found, particularly amongst lawyers. I don't want to be face the wrath of Mr. Jetmalani.